Hello and welcome to Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. To that end, we upload content every single day at 8 a.m. Eastern Standard Time. Don't forget to like, subscribe, and click the notification bell if you like the content coming up. Here is question number 1. Penn sues Duke's Bar for injuries suffered in an automobile accident caused by Chase, who had been a patron at Duke's Bar. Penn claims that Chase was permitted to drink too much liquor at Duke's Bar before the accident. Duke's Bar called Chase to testify and expected him to say that he was sober when he left Duke's Bar. However, on direct examination, Chase testified that he may have had a little too much to drink at Duke's Bar. Duke's Bar now seeks to confront Chase with his statement made on deposition that he was sober when he left Duke's Bar. Which of the following is true concerning this statement? A. It may be used only to refresh Chase's recollection. B. It is admissible for impeachment and as substantive evidence that Chase was sober. C. It is inadmissible because Duke's Bar cannot impeach its own witness. Or D. It is inadmissible because it is hearsay not within any exception. Take 10 seconds. Choose the best answer now. If you chose option B, you'd be right. It is admissible for impeaching and as substantive evidence that Chase was in fact sober. Under the federal rules of evidence, the credibility of a witness may be attacked by any party, including the party calling that very witness. A prior inconsistent statement of a witness who testifies at trial is not hearsay if it was given under oath at trial or deposition. If so, it is admissible to prove the truth of the facts in that statement. If not given under oath, it is hearsay and inadmissible to prove the truth. In this case, Duke's Bar seeks to impeach its own witness, Chase, by offering his prior inconsistent statement. This is permissible under the federal rules of evidence because Chase's prior inconsistent statement was made in a deposition. It can also be used to prove the truth of the facts in the statement, i.e., that Chase was in fact sober when he left the bar. Therefore, Chase's statement is admissible for impeachment and as substantive evidence that Chase was in fact sober. Based on that analysis, you look at option D. It is inadmissible because it is hearsay not within any exception. Again, it is not hearsay because it is sworn testimony and part of the record before this court. C. It is inadmissible because Duke's Bar cannot impeach its own witness. That is, without question, untrue. Any party can impeach a witness, including their own witness. And option A. It may be used only to refresh Chase's recollection. The issue here is that the witness has not stated that he forgot. He stated something that is the exact opposite of what the transcript of the deposition said. So as a result, the most appropriate course of action would be to utilize that information to impeach him. Question number 2. Defendant is charged with assault and battery. The state's evidence shows that victim was struck in the face by defendant's fist. In which of the following situations is defendant most likely to be not guilty of assault and battery? A. Defendant had been hypnotized at a party and ordered by the hypnotist to strike the person he dislikes the most. B. Defendant was suffering from an epileptic seizure and had no control over his motions. C. Defendant was heavily intoxicated and was shadowboxing without realizing that victim was near him. Or D. Defendant, who had just awakened from a deep sleep, was not fully aware of what was happening and mistakenly thought victim was attacking him. Take 10 seconds and choose what you think is the best answer now. If you chose option B, you'd be correct. Defendant was suffering from an epileptic seizure and had no control over his motions. Battery is the intentional or criminally negligent application of unlawful force to another resulting in either bodily injury or offensive touching. Assault is either an attempt to commit battery or the intentional creation of reasonable apprehension of imminent bodily harm. The act of the defendant must be voluntary in order to be held criminally liable. In other words, the act must be the product of the actor's own volition. No non-voluntary act, including reflexive or convulsive acts such as seizures, can meet this standard. Here, defendant would not be criminally liable for an assault or battery committed while having a seizure. Defendant's seizures resulted in non-voluntary motions without the intent necessary for the motions to constitute assault or battery. While being hypnotized may also result in non-voluntary motions, the defendant in A could still be guilty of battery by being criminally negligent in allowing himself to be hypnotized at a party. In contrast, B has no such indication of criminal negligence. Thus, the defendant in B is most likely not guilty of assault and battery. If we look at option C, the intoxication question, self-intoxication or intoxication on purpose generally is not used in order to relieve mens rea. D, defendant who had just awakened from a deep sleep was not fully aware of what was happening and mistakenly thought victim was attacking him. This is a unilateral error, as we would say in contracts, and in essence, his error would not generally limit him from liability. So as a result, again, B would be without question the best response. Question number 3. The strongest constitutional basis for the enactment of a federal statute requiring colleges and universities receiving federal funds to offer student aid solely on the basis of need is the A, police power, B, war and defense power, C, power to tax and spend for the general welfare, or D, power to enforce the Privileges and Immunities Clause of the 14th Amendment. Take 10 seconds. If you chose option C, power to tax and spend for the general welfare, you'd be correct. Article 1 sets forth the legislative power. Under Article 1, Congress may spend to provide for the common defense and general welfare. Here, the federal statute provides that colleges and universities receiving federal funds must offer student aid solely on the basis of need. The student aid condition placed on receiving federal funds provides for the general welfare by ensuring student aid is dispersed in order of need. So the condition is likely within Congress's spending power. Accordingly, the strongest constitutional basis for the enactment of a federal statute requiring colleges and universities receiving federal funds to offer student aid solely on the basis of need is the power to tax and spend for the general welfare. Question number 4. Penn sues Duke's Bar for injuries suffered in an automobile accident caused by Chase, who had been a patron at Duke's Bar. Penn claims that Chase was permitted to drink too much liquor at Duke's Bar before the accident. Penn offers evidence that after the accident, the manager of Duke's Bar established house rules limiting all customers to 2 drinks per hour, with a maximum limit of 4 drinks per night. This evidence is A, admissible to show the prior conduct of Duke's Bar was negligent, B, admissible to show that Duke's Bar was aware of the need for taking precautionary measures, C, inadmissible because subsequent measures by an employee are not binding on Duke's Bar, or D, inadmissible because its admission would discourage the taking of such remedial measures. Take 10 seconds. If you chose option D, you'd be correct. Inadmissible because its admission would discourage the taking of such remedial measures. Evidence of safety measures or repairs after an accident is inadmissible to prove culpable conduct or to prove defective product design in a product's liability action. Such evidence, however, is admissible to prove anything other than negligence or defective product design, but the court must balance unfair prejudice against probative value. In this case, the new house rules limiting drinks at Duke's Bar are inadmissible to prove culpable conduct on permitting Chase to drink too much liquor before the accident. The public policy rationale is to encourage people to take remedial measures instead of being afraid that taking such remedial measures will expose them to liability for not taking action earlier. Therefore, evidence about the new house rules is inadmissible because its admission would discourage the taking of such remedial measures. Question number 5. While driving at a speed in excess of the statutory speed limit, Dant negligently collided with another car, and the disabled vehicles blocked 2 of the highway's 3 northbound lanes. When Page approached the scene 2 minutes later, he slowed his car to see if he could help those involved in the collision. As he slowed, he was rear-ended by a vehicle driven by Thomas. Page, who sustained damage to his car and was seriously injured, brought an action against Dant to recover damages. The jurisdiction adheres to the traditional common law rules pertaining to contributory negligence. If Dant moves to dismiss the action for failure to state a claim upon which relief may be granted, should the motion in fact be granted? A, yes, because it was Thomas, not Dant, who collided with Page's car and caused Page's injuries. B, yes, if Page could have safely passed the disabled vehicles in the traffic lane that remained open. C, no, because a jury could find that Page's injury arose from a risk that was continuing consequence of Dant's negligence. Or D, no, because Dant was driving in excess of the statutory limit when he negligently caused the first accident. Take 10 seconds and choose the best answer now. If you chose option C, you'd be correct. No, because a jury could find that Page's injuries arose from a risk that was a continuing consequence of Dant's negligence. The doctrine of proximate cause is the philosophical connection that limits liability to consequences that bear some reasonable relationship to the defendant's conduct, so as to not offend notions of common sense, justice, and logic. The defendant is liable for all damages caused by foreseeable intervening events of his own negligence, such as subsequent accidents, substantially caused by the original injury. In this case, Dant's negligence caused the initial collision. It was reasonably foreseeable that another driver like Page would slow to help those in that collision. A jury could easily conclude that Dant's liable for Page's subsequent accident after Page slowed to help if Page's accident was substantially caused by Dant's original negligence. Therefore, Dant's motion should not be granted, because a jury could find that Page's injury arose from a risk that was a continuing consequence of Dant's negligence. Question number 6. A federally owned and operated office building in the state of West Dakota is heated with a new pollution-free heating system. However, in the coldest season of the year, this new system is sometimes insufficient to supply adequate heat to the building. The appropriation statute providing the money for the construction of the new heating system permitted use of the old pollution-generating system when necessary to supply additional heat. When the old heating system operates only about 2 days in the year, the smokestack of the building emits smoke that exceeds the state of West Dakota's pollution control standards. May the operators of the federal office building be prosecuted successfully by West Dakota authorities for violating that state's pollution control standards. A, yes, because the regulation of pollution is a legitimate state police power concern. B, yes, because the regulation of pollution is a joint concern of the federal government and the state. Therefore, both of them may regulate conduct causing pollution. C, no, because the operations of the federal government are immune from state regulation in the absence of federal consent. Or D, no, because the violations of the state pollution control standards involved here are so de minimis that they are beyond the legitimate reach of state law. Take 10 seconds. If you chose option C, you'd be correct. No, because the operations of the federal government are immune from state regulation in the absence of federal consent. Article 6 provides that the Constitution and law made pursuant to it are the supreme law of this land. This clause renders any contrary state legislation void. A state may regulate more extensively than a federal statute, so long as this does not frustrate the objective of the federal statute. A state may not, however, pass a law that excludes conduct that is included in a federal law. States may not regulate federal activities. In this case, the appropriation statute permitted use of the old pollution-generating heating system in the federally owned and operated office building. West Dakota is not permitted to regulate the federal government's operation of its office building, since barring the old heating system means inadequate heat would be supplied to the building during the coldest times of the year. Additionally, the federal government did not consent to West Dakota's regulation of its operations. Therefore, the operators of the federal office building cannot be prosecuted successfully by West Dakota authorities for violating that state's pollution control standards, because the operations of the federal government are immune from state regulation in the absence of federal consent. Question number 7. Police officer stopped Dexter for speeding late one night. Noting that Dexter was nervous, he ordered him from the car and placed him under arrest for speeding. By state law, a police officer was empowered to arrest Dexter and take him to the nearest police station for booking. He searched Dexter's person and discovered a package of heroin in his jacket pocket. Dexter is charged with possession of heroin. At trial, Dexter's motion to prevent introduction of the heroin into evidence on the ground that the search violated his federal constitutional rights will most probably be A. Denied because the search was incident to a valid custodial arrest. B. Denied because police officer acted under a reasonable suspicion and legitimate concern for his own personal safety. C. Granted because there was no reasonable or proper basis upon which to justify conducting the search. Or D. Granted if police officer was not in fear and had no suspicion that Dexter was transporting narcotics. Take 10 seconds. If you chose A, denied, because the search was incident to a valid custodial arrest, you'd be correct. In certain situations, an investigatory search may take place without an arrest. A search incident to lawful arrest may also take place without a warrant. The arrest must take place before the search, however. The search must be contemporaneous in time and place with the arrest, and the scope is limited to the suspect and their wingspan. In this case, police officer lawfully stopped and arrested Dexter for speeding. Police officer then conducted a valid search incident to lawful arrest and discovered the heroin in Dexter's pocket. This search did not violate Dexter's constitutional rights. Accordingly, Dexter's motion to prevent introduction of the heroin into evidence will most probably be denied because the search was incident to a valid custodial arrest. Question number 8. Alice entered into a contract with Paul by the terms of which Paul was to paint Alice's office for $1,000 and was required to do all of the work over the following weekend so as to avoid disruptions of Alice's business. For this question only, assume the following facts. Paul commenced work on Saturday morning and had finished half the painting by the time he quit work for the day. That night, without the fault of either party, the office building was destroyed by fire. Which of the following is an accurate statement? A. Both parties' contractual duties are discharged and Paul can recover nothing from Alice. B. Both parties' contractual duties are discharged, but Paul can recover a quasi-contract from Alice. C. Only Paul's contractual duty is discharged because Alice's performance, payment of the agreed-upon price, is not impossible. Or D. Only Paul's contractual duty is discharged and Paul can recover his reliance damages from Alice. Take 10 seconds and choose what you believe to be the best answer. If you chose option B, both parties' contractual duties are discharged, but Paul can recover a quasi-contract from Alice, you would be correct. Impossibility occurs when A. Circumstances affecting the contract have changed, B. The change is not due to any act by the defendant, and C. The change in circumstances causes performance to be impossible for the defendant. However, a party to a contract whose performance is discharged by impossibility will be entitled to restitutionary remedies for any benefit conferred to the other party by part performance prior to the change in circumstances that made performance impossible. In this case, Alice entered into a contract with Paul to have Paul paint Alice's office. Paul was required to complete work over the following weekend. Paul had finished half of the painting by the time the office was destroyed by fire without the fault of either party. Since the destruction of the subject matter of the contract discharges the duty to perform under the theory of impossibility, both parties' contractual duties were discharged when the building was destroyed by fire. However, since Paul had painted half of the office, Paul will be able to recover in quasi-contract for the value of the benefit which he conferred upon Alice prior to the destruction of the office. Question number 9. Green is cited for contempt of the House of Representatives after she refused to answer certain questions posed by a House committee concerning her acts while serving as a United States ambassador. A federal statute authorizes the Attorney General to prosecute contempts of Congress. Pursuant to this law, the House directs the Attorney General to begin criminal proceedings against Green. A federal grand jury indicts Green, but the Attorney General refuses to sign the indictment. Which of the following best describes the constitutionality of the Attorney General's action? A. Illegal, because the Attorney General must prosecute if the House of Representatives directs them to. B, illegal, because the Attorney General must prosecute those who violate federal law. C, legal, because ambassadors are immune from prosecution for acts committed in the course of their duties. Or D, legal, because the decision to prosecute is an exclusively executive act. Take 10 seconds. You'd be correct if you chose option D, legal, because the decision to prosecute is an exclusively executive act. Article 2 vests the executive power in the President and states the President shall take care that the laws be faithfully executed. Discretion regarding the enforcement of laws lies within the executive branch. The Attorney General is a member of the executive branch. In this case, a federal statute authorizes the Attorney General to prosecute contempt of Congress. The Attorney General has discretion in choosing whether to prosecute Green's contempt of Congress. The Attorney General chose not to sign Green's indictment. Therefore, the best description of the constitutionality of Attorney General's action is that it was legal because the decision to prosecute is an exclusively executive act, and the Attorney General, in fact, is an executive actor. Question number 10, the last question in this grouping. Penn sues Duke Sparr for injuries suffered in an automobile accident caused by Chase, who had been a patron of Duke Sparr. Penn claims that Chase was permitted to drink too much liquor at Duke Sparr before the accident. Penn offers evidence that after the accident, the owner of Duke Sparr visited him at the hospital and, offering to pay all of Penn's medical expenses, said, "That's the least I can do after letting Chase leave the bar so drunk that night." The statement that Chase was drunk when he left the bar on the night of the accident is A, admissible as an admission by the owner of Duke's Bar that Chase was drunk when he left the bar. B, admissible as a factual admission made in connection with an offer of compromise. C, inadmissible as hearsay not within any exception. Or D, inadmissible as a statement made in connection with an offer to pay medical expenses. Take 10 seconds. I hope you ended on a positive note and chose option A, admissible as an admission by the owner of Duke's Bar that Chase was drunk when he left the bar. Remember, hearsay is an out-of-court statement offered to prove the truth of the matter asserted in that very statement. Hearsay is generally inadmissible. An admission of party opponent is admissible as a hearsay exemption because it is not hearsay under the federal rules of evidence. An admission of party opponent is a statement by a party or by someone whose statement gets attributed to that party offered by the party opponent. Evidence of an offer to pay medical expenses is inadmissible to prove liability for injuries in question, but related statements are still admissible. In this case, the owner of Duke's Bar made an admission to Penn that he had let Chase leave the bar drunk that night. The owner of Duke's Bar is being sued by Penn, so the owner's admission is an admission of party opponent and is, as a result, admissible as a hearsay exemption. The owner's statement is not considered admissible as an offer to pay medical expenses because the admission was a separate statement from the offer. Therefore, the statement is admissible as an admission by the owner of Duke's Bar that Chase was in fact drunk when he left the bar. As always, thank you for joining us on Bar 10, where it's our goal to help you prepare for the bar exam 10 questions at a time. As always, to that end, we upload content every day at 8 a.m. Eastern Standard Time. Don't forget to like, subscribe, and click the notification bell so you can be updated every time we upload new content.